Hello and welcome to this session in which we will discuss Chapter 15 Bankruptcy. Chapter 15 Bankruptcy is the part of the United States Bankruptcy Code, but it's dealing with cross-border insolvency and bankruptcy issues. Now, in the prior sessions, we looked at Chapter 7, which is liquidation, and Chapter 11, which is reorganization. And those are the main two that you will need to know on the CPA exam. But you might see a multiple choice about Chapter 15. So let's go ahead and give you an overview just in case that happened. So Chapter 15 is designed to provide an efficient and effective mechanism for handling insolvency cases that involve assets, debtor and claimant, and other parties that are involved or located in more than one country. So we might have a business person living in Europe, but they have assets in the US as part of their business. They have creditors in the US. Therefore, if they file in Europe, their assets here, what's going to happen to their asset? So Chapter 15 would deal with cases like this. So we're going to go through a brief overview just to give you, as I mentioned, just an overview. Before we proceed any further, I have a public announcement about my company, farhatlectures.com.
Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today.
Let's start by discussing the purpose of Chapter 15. Well, the purpose is to promote cooperation between the U.S. court and parties of interest with foreign insolvency proceeding. And those parties could be individual filing for bankruptcy or multinational companies, a high net worth individual that have assets all over the place, as well as creditors. And this cooperation supposed to do what? Facilitate fair and efficient administration of cross-border insolvencies, protecting the value of the debtor's asset and the creditor's interests. And also ensures, we want to make sure that creditors are not discriminated against and mandate a high degree of cooperation and communication between the U.S. and the foreign legal bodies. Now, how does the process start? Just like with any bankruptcy process, whether it's 11, 7 or 15 or any other one, you have to file a petition. A foreign representative, and we'll talk about their role shortly, from a bankruptcy proceeding in another country can file a petition. So they file in that foreign country, now they file a petition in the US for recognition of the foreign proceeding under Chapter 15 in a US bankruptcy. So because they want this case to be active in the US, therefore they file under Chapter 15. It needs to prove, the petition needs to prove there's an ongoing insolvency or bankruptcy proceeding in another country, and the petitioner, the foreign representative, is officially appointed and authorized to act in that proceeding, because we need someone to act on behalf of that foreign entity. Once the foreign proceeding is recognized by the U.S. court, various forms of relief become available to assist the foreign representative in the goals of the foreign proceedings. Now, we could have two types of proceeding. The U.S. court can recognize two types. During the hearing, the U.S. court decide whether to recognize the foreign proceeding. The court can recognize it as either a foreign main proceeding, which means the bankruptcy case in a country where the debtor's primary business interests are located, or a foreign non-main proceeding. If the case is in a country that isn't the debtor's main business interests are. If the court recognizes the foreign proceeding as the main proceeding, certain automatic protection under U.S. Bankruptcy Code comes into effect. For example, automatic stay on actions against the debtor's asset in the U.S. Therefore, they have some sort of a protection from legal proceeding against their asset. So the relief is provided once the recognition happens. Chapter 15 can provide a range of relief, including but not limited to staying action, which is stopping legal proceeding against the debtor's asset in the U.S., providing for the examination of witness, allowing the foreign representative to operate the debtor's U.S.-based business. Also, the representative can have other roles. Beside managing the debtor's business, they can engage the U.S. legal system to seek further protection, initiate comprehensive bankruptcy cases if needed, 7 or 11 under certain circumstances, and involve themselves in any ongoing legal matters related to the debtor. Remember, they are the foreign representative of that debtor. this broad scope of power is designed to facilitate the effective management and resolution of cross-border insolvency cases. And I would say those are the main ideas that you'll have to know for the CPA exam. In case you saw a question or two, I really don't know, but we have to cover this topic. Anyhow, go to Farhat Lectures, look at additional multiple choice questions, look at the resources that's going to help you, whether you are studying for your CPA exam or taking a business law course. Invest in yourself, good luck, and of course, stay safe.